approach the podium, Your Honor?
Please. All right.
Thank you, Your Honor. Your Honor, again, just for purposes of the record, Mr. Frank and I had a discussion last evening about which motions to address today, and we agreed upon numbers 18, 19, and 21 of the defense motions in limine, as well as number 4 in the state's motions in limine. I think as a threshold matter, Your Honor, I think there is actually one correction that came to my attention from yesterday, and maybe we can address that later with respect to rule number 5, or excuse me, motion number 5.
All right.
Dispatching with perhaps the easiest of the three, number 19 of the defense motions, excuse me one second, I believe is identical to state motion number 5, and therefore we have no objection to that order being granted.
All right, 19 is granted without objection.
Your Honor.
Yes, identify yourself for the record, please.
This is Sunday Byer for the state of Minnesota. There is one objection we have to the Chauvin's motion 19. The state opposes the motion to the extent it precludes testimony not just on subsequent changes to MPD policies, which we agree absolutely should be excluded, but also on MPD policies on which Chauvin was trained, but that might not have been in effect at the time of Floyd's death. Policies on which Chauvin was trained are definitely relevant.
It's Mr. Chauvin, please.
Whether Chauvin had the requisite mens
Mr. Iyer? Mr. Iyer? We refer to everyone by title, so it's Mr. Chauvin, please.
Oh, my apologies, Your Honor. So this court recognized that whether Mr. Chauvin was trained on a particular policy is relevant in determining whether he had the requisite mens rea, and it recognized as much in this probable cause order when it indicated that Mr. Chauvin's failure to follow training would be potentially probative, for example, of a gross deviation from the standard of care, of whether he consciously took a chance of causing death or great bodily harm, and of potential recklessness. And so for that reason, the state respectfully asks that the court deny the motion to the extent it seeks exclusion of training Mr. Chauvin received that might not be reflected in the MPD policies that were in effect at the time of Mr. Floyd's death.
So what I hear you saying is it was not policy, but they were training on a certain topic. Mr. Chauvin received that training, and you want to be able to comment on that even though it was not firmly in policy yet.
That's correct, Your Honor.
Mr. Nelson.
I'm trying to figure out if you're talking to me or him. Sorry, this is an awkward arrangement.
True.
Because I see 1, 2, 3, 4, 5, 6 of 7, 8. So I apologize, Your Honor. I'm not trying to be glib. It's just
No, actually, I'll address you specifically if I need to. Mr. Iyer, what is that kind of what you're saying?
Yes, Your Honor, it is.
Okay, Mr. Nelson, do you have?
Yes, Your Honor. In terms of training through the Minneapolis Police Department, that's obviously going to be a significant issue throughout the course of Mr. Chauvin's career. What our motion specifically was addressing is any policy changes subsequent to the incident at question here. We are in agreement that those policies, I think we're both in agreement that those policies should not be referenced during the course of the trial, those changes. With respect to his other training, I guess I would seek clarification from counsel simply because there are training methods that have been approved. If we're talking policy versus training, I guess that's the question that I would have.
All right. You are, Mr. Iyer, you are essentially trying to get in the training that he had. I don't see any reason why that would not be relevant. I think that comes in, regardless of whether it's been embedded in policy or not. So I think we can probably deal with this when it comes up. drawing the lines on appropriate testimony, but if it's training Mr. Chauvin received before the death of Mr. Floyd, I think we have to recognize that that is relevant, and I would allow it, regardless of policy. All right, does that answer the question, Mr. Iyer?
Yes, it does. Thank you, Your Honor.
All right. And the next, we are number, is it 21?
Number 18, Your Honor.
18, I'm sorry.
18 and 21 are the remaining two. Your Honor, and perhaps my motion needs a little clarification. Number 18 seeks to prohibit witness police officers from testifying or speculating about what they would have done if they had been the person who arrested Mr. Floyd. We recognize that under the Graham versus Connor standard, that the question here is whether this was a reasonable use of force. And there are expert witnesses who are going to testify for the defense. There's expert witnesses who are going to testify for the state as to that ultimate question in terms of the reasonableness of the force. We also expect training officers from the Minneapolis Police Department to testify about how officers are trained in the Graham versus Connor factors, in the reasonableness of the use of force and MPD policy, and all of that I think is 100% fair game.